Thanks everyone for joining us. This Financial Poise webinar, The Very Basics, Forming the Business, is part of the Startup Small Business Advisor 2026 series and is sponsored by the National Law Review and Max Asset. Slide 7 of the deck summarizes this episode, and slides 8 and 9 summarize the series. Speaking of the slides, we're not going to step through the slide deck in any particular order, nor will you have to listen to us read any of the slides. This webinar, like all Financial Poise webinars, is an informal conversation. If you're so inclined, you can keep the deck handy. You can take a printout of it if you wish to take notes. We may indicate what slides our conversation is touching upon, but as more often than not with these webinars, they tend to be more informal chats, and we bounce around a little bit, and we're not really slide-centric. Our panelists are, and we are joined today by David Lopez Kurtz. David is a partner at Croak Fairchild Duarte and Barris, which is a full-service firm located in Chicago and Milwaukee, where he focuses on emerging technology, including digital assets, blockchain technology, and artificial intelligence, large language models. David's practice also encompasses traditional corporate and securities matters, business formation, fundraising, mergers and acquisitions, and regulatory compliance. Robert Seeland is with us today. Following years of serving as in-house counsel, Robert is a principal at Much Shell PC based in Chicago. He served as a senior legal executive at 3 publicly traded companies and is a corporate and securities law attorney supporting his clients with M&A, compliance, fundraising, and the negotiation of sophisticated commercial agreements. Lastly, but not leastly, we're joined by Andrew Kimball. Andrew is an associate at Norris McLaughlin, PA, which is a full-service law firm representing clients throughout New Jersey, New York, and Pennsylvania, where he represents middle market and lower middle market businesses, joint ventures, startups, sponsors, borrowers, lenders, search funds, investment funds, and buyers and sellers in a range of corporate and transactional matters. He's experienced preparing companies going to market and advising on the issues and steps required in marketing and selling a business. I am your moderator. I'm Robert London. I'm a partner at Jasmine Schlesinger Narendran, which is a full-service law firm in Garden City, New York, which is just outside of Manhattan. My practice as a transactional attorney spans from M&A to venture capital to startups to executive compensation matters. Basically anything that's tough to negotiate and fun to draft and vice versa is what I do. I know you are enthralled with our bios. I'm sure you're spending your money just so you can hear about us. If you really want to learn about us, our bios are at the back of the deck. This webinar is a production of Financial Poise. More about Financial Poise can be found on slide 40 of the deck. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching or listening to this on demand, or have any questions about the webinar, you can send an email to info@financialpoise.com. Remember, the deck, the conversation you're about to listen in on, are all meant for general educational purposes and do not replace the need to consult with an appropriate attorney, accountant, or other professional. In other words, if you take significant action based on something that you might hear today, you might end up with a result that you don't like and might have found out that you did something sort of silly. Once again, thanks to the National Law Review and Max Asset. You can learn more about our sponsors on slides 38 and 39 of the deck. So this is episode 1 of a 4-part series, and typically I've done and moderated these in the past. I like to have a basis for a business for our entrepreneurs, our pretend entrepreneurs, to try to percolate here. So throughout the discussion today, we're going to chat about early stage hurdles and concerns. In prior webinars, I've gone high tech. I think this time, for the sake of a little variety, because variety is the spice of life, this time around, we're going to go lower tech with the goal of having a different discussion than in prior webinars. Our venture for today's webinar is a manufacturing company for the production, marketing, and sale of patented injection plastic molds. So that's both going to be a little bit of IP and a fair amount of manufacturing, as well as with the typical marketing and growth concerns. So let's get this party started. I'm going to start with Robert. Our app development team consists of 3 friends, and they're all sitting at a Starbucks. What sorts of problems might arise if our entrepreneurs move forward as a general partnership? Take it away.
Yeah, general partnership is kind of the nightmare scenario that most young attorneys hear about, and let me tell you why. When you form a general partnership, default rules apply, and the defaults are essentially that you share the liability of the business 100% amongst the three of you. Um, you and so if let's say there's a lawsuit, you don't split that liability three ways. If one person can't pay, the other two are on the hook to pay the rest of it. It's joint several liability for everyone. There's lots of questions about governance. It kind of clouds your ability to do any fundraising. You have unlimited liability for any claims. It's all personal liability to you. And kind of the list of horrors just kind of continues. Not most businesses don't form a partnership, a general partnership, because there's just so much value in an organized entity for not much cost that we don't see it much. There might be. I'm actually aware of only one enterprise ever in my life that actually has pursued that, and they did it for a from the standpoint of kind of presenting that they trusted their partners so thoroughly that they would take that risk. But I don't think that risk is really worth that potential selling point. You want to be um, you want to be able to present yourself in the market as a peer of other companies in the market, and that starts with having the basics and getting your organization, your company set up and showing that you care about that.
Wow, did you do a memo to file after recommending that maybe they reconsider true general partnership? I've never seen that before.
Yeah, that was that is all anecdotal as I heard. I would never recommend it myself.
All right, well, I'm going to stick with you. Given that, uh, let's go digital with zeros and ones here, given typically general partnership bad, what are the other business forms that are typically available under state law that might be a good instead of a zero?
Yeah, so the general forms that most people talk about, there are a lot of forms. But the general forms people speak of are an LLC, a C corporation, or an S corporation. A C corporation and S corporation are under most state laws essentially the same entity. It's just a tax classification. And an LLC could be classified like a C corp, but often is usually treated as a partnership. So we haven't really spoken about the distinction of kind of tax classification and corporate entity. But when people kind of generally discuss these businesses, they think of a S corporation as kind of having kind of partnership tax light characteristics. There's pass-through taxation that we can speak about. An LLC is much like a partnership, but it's got limited liability. An entity that was commonly used and still is used in some contexts before an LLC came about was a limited liability partnership. But the concept is that it's essentially you have the tax benefits of a partnership, the flexibility of a partnership that can be documented however you want in a partnership agreement, but you have the limited liability of a corporation. And then you have the traditional C corporation, which is again, it's an organized entity filed under state law, under a state charter with limited liability. But the investors don't pay taxes on the profits or don't get to use the benefit of the losses of the entity itself. There's double taxation, they call it, meaning there's no pass-through taxation. You will pay a tax, the corporation will pay its own tax, and then if money is distributed to shareholders, then the shareholders will pay their own tax as well. That's the double taxation. So you have basically those three entities. Um, there are other entities that are related, such as, if you're getting into the practice of medicine or you're getting into banking, there are specific entities for those. But as a general organization, let's say we're talking about this manufacturing business, those are your three general choices.
Great, thanks. I mean, I play a doctor on television, so I don't think I need the PLLC or the specific ones that require a license, other than for an attorney.
That's right.
So among those alternatives, among the ones, not the zero general partnership, all are pretty good from a limitation of liability standpoint. Are there any unusual or strange quirks that, where one might be, better or worse off than another?
Well, I'd say that if you have an LLC, kind of how it operates is 100% dependent on how you draft the operating agreement, the kind of the governing documents of it. So you can have a governing document. I would advise you to be careful if someone says, "Hey, this is a standard LLC agreement, just sign it," because they're never standard. And you can imagine you've got infinite flexibility there. So, for instance, one partner could take all of the losses of that business and allocate them to themselves. And therefore, that partner just got a tremendous tax windfall of saving on their personal tax liability. And none of the other partners get the benefit of that, even though they might have made significant investments in the business. That flexibility is wonderful because you can kind of allocate benefits and burdens of the business to different partners in different ways, and it can get complex there. But you also need to spend you pay some attention with that. The corporations and S corps are much more standard. Charters mostly look the same. S corps can only have one form of equity, and there are restrictions on how many. You can only have 100 shareholders of an S corp, and the shareholders have to be individuals. I believe they also must be U.S. citizens or U.S. residents. So those restrictions, if you fail to comply with those restrictions, you lose the tax benefits of the S corp. So you need to be very careful about that. And the C corp is much like the S corp from the standpoint of formation, but it doesn't have those same tax benefits. It is, again, double taxation. From a liability perspective, the liability of these entities is really a function of what you do with them. If you go to LegalZoom and you have someone say, "Get me this business," and they say, "Here's your business entity, congratulations," and you failed to do anything to treat it like a separate business, you didn't have separate bank accounts, you never got insurance, you never titled your assets in the name of the business, it won't afford you much protection at all. Courts will look past that entity and look to you for personal liability. But if you do treat it as a separate business, all of them, I would say, protect your liability, you from personal liability, almost the same.
Great, thanks a lot. Okay, let's move on. Let's introduce David to the discussion. David, can you describe the generic attributes of a first-time startup entrepreneur, and what are some of the early lessons that he or she might learn?
I mean, this is somebody who's brave at the end of the day. I mean, it's a big and a bold decision to strike out on your own and to build something that hadn't been built before, or to build a better version of something that has. One way or the other, entrepreneurs are brave and they're bold people um, by their very nature, and is evidenced in their actions. And the lessons they can learn. I mean, there's so much. Like it's really astounding the difference between a first time founder and a second time founder. Just it's like they've lived an entire lifetime in between those life cycles. I've had the opportunity and privilege in my career to represent founders from incorporation through exit, and then meet them again the next time they go through it, and it's really tremendous. I think some of the big ones I'd flag for people, um, and that I hear say, "I wish I'd known this the first time around." It's the measure twice, cut once kind of decisions, particularly around things. And I know I'm biased because this is what I do and what I see. But when it comes to doing your legal setup and making sure that you're sitting on a strong foundation, and in that same breath, not overspending on your service providers early on. There's no reason to engage a big four accounting firm when you are just out the gate and working on your startup for the very first time. There's no reason to engage a partner at a firm that's charging you $2,800 an hour. There may be a time and a place when your company has grown to the point where these are reasonable expenditures from the perspective of your board, but early on, finding the right fit of the right people around you and investing the time in that, and then investing the capital necessary to do things right the first time, because you end up paying for it many fold over if you try cutting corners early on.
Thanks. Andrew, welcome on in. Come on in. Sit beside the fire here. Put your marshmallow on a stick, and let's talk about what are some questions that an entrepreneur should consider and be able to answer both intelligently and comprehensively before commencing a search for capital. What are some of the basic foundational things that they should not be surprised that they fail to answer if presented with an opportunity to get some money?
Definitely. So a threshold point would be just describing and explaining your business, descriptively, but succinctly, what it does and how you produce your product or your services. This is often, in the form of a solution to a problem, some way for a potential investor to relate to what your business is and the products and services you offer. Oftentimes you'll be asked, related to that, do you have an actual written out business plan? Do you have an abbreviated business plan? Some form of step deck or a slideshow that actually shows some of the details in an easily readable and digestible fashion. Then proof of concept for a product is often a question that will come up. Has this product been tested? Does it work? How does it work? Other big questions I think would be, what are your costs to manufacture? And what does it cost you to deliver your products or your services? Essentially, we're getting at, profit margin here. They want to know what they're looking at and what they might be getting into. And then looking more broadly, the overall market. You want to describe the market you're in, potential competitors, what makes you unique or different. And then, and the other questions might be, what type of financing have you tried to obtain? Do you have investors? Do you have debt financing? Are you looking for debt financing? Are you looking for equity investment? People would join in the ownership of the entity with you. And related to that, in terms of connection with questions about equity would be, how much are you willing to give up? How many stakeholders are there in the beginning? What's the opportunity like for the future for other equity holders? And who am I doing business with? And I think also something I've seen a lot is a personal question of, what have you done? What type of sweat equity have you done? What's your background? Where are you coming from? What have you invested in it? So those are some of the big ticket items, I'd say. Other things would be, you could get into the intellectual property, the specifics, potential risks to the business. What's your plan for acquiring customers? Things like that.
Thanks. I think the only cherry that I would add to the sundae that you made is, depending on the type of person you're going to be speaking to, and we'll probably get into this a little later, is what's the exit? Like, I'm not sure, given our generic patented injection plastic mold business, whether this is something that we are building to sell it to a conglomerate or to private equity, or if it's something that we think that we could pass down and operate through generations. But the idea of an exit, depending upon the type of investor you're speaking to, is probably at least a little hot fudge whipped cream and a cherry there as well. Anyone else have any thoughts? I mean, the other thing you said, I'm not sure that I would be ready to, if I was a founder, to volunteer what I'm willing to be diluted to.
Right.
I think I might say, well, that's, it's a function of my, enterprise value. And that is, I think we all know, enterprise value is basically set as to what's the highest you can get so that you can keep as much of the equity as you want and get as much money as you want. So I would consider all those things. Anyone have anything else they want to add before we bump around a little bit here at our campfire? All right, rock and roll. Let's go back to Robert for a little bit. Next, I'm going to stick with Andrew. Andrew, can you explain some of the principal differences among the different entity forms from management and how things get run and how management decisions are made? A
Sure,
little bit on
definitely.
each would be great.
Yeah, definitely. So I'll mention sole proprietorship. I know we're really focusing on limited liability companies, C-Corps, S-Corps, and we've talked about partnerships, but a sole proprietorship does exist. It's just you, an individual, no liability protection. You call the shots. There's the partnership, which we've discussed, the partner share control and decision-making authority. As we talked about at the top, a partner's decision bind the other partners and the entity, and you share in that liability. There also is a limited partnership, which would have one general partner. This is normally for, investments type funds where you'd have passive investors as the limited partners. But going to the main focus would be, so an LLC, you can have a manager managed LLC, or you can have a member managed LLC. So manager is what it sounds like. You would appoint a manager or a group of managers, or you can have a board of managers, which is similar to a board of directors for a corporation. So the managers can appoint officers in an LLC if it's not required, because the managers themselves can, handle day-to-day decisions and business for the entity. But you could appoint officers who would do those functions as well. So then you have member managed, which is the default under state law, most state law, and definitely New Jersey, New York, Delaware. And that's where the members manage the entity. And yeah, like I said, unless it's put in your operating agreement that this is a manager managed LLC, you'd be defaulting to a member managed. And then you have to keep in mind, though, that certain major decisions will always require the input of members, such as dissolving, selling the company, things like that. So moving on to a corporation, C Corp and S Corp, you're going to have a board of directors. They're elected by the shareholders, which own the shares of the entity. The board is going to appoint officers that will handle the day-to-day business. The board also would be typically responsible for financial decisions, entering into contracts, approving different business moves and actions. And then similar to the point I mentioned on the LLC, certain major actions will require shareholder approval, selling the company, amending a certificate of incorporation. And then we touched on the S Corp, there's those limitations, no more than 100 shareholders, US based, can't have any entities. One thing also, there's preferred shares. You cannot have preferred shares, which is just a different class of stock. But that's generally it.
Thanks a lot. We're going to go move on to a little bit about finance now. We got smart money with us because we have David with us. David, let's talk about money. Our developers need capital. Can you explain the principal differences among some of the entity types we discussed along the dimensions of attractiveness for, let's stick with equity funders right now.
Sure. So talking about equity, I mean, you're going to have, if you're talking about limited liability company, you're going to be talking about membership interests. So it's the amount of that limited liability company that you own. They're very much like partnership interests, depending on how you've made your tax decisions when it comes to treat the way you treat your entity there. They can be structured in a way where it's just a percentage. You own X% of the company. Other times they look a little bit more like the equity units of a corporation. They look a little bit more like stock, and you have membership units, and those rights within that limited liability company, they run the gamut. It's the limited liability companies are creatures of contract, and every contract you can think of, everything you can innovate, invent, you can find it, and will find it in somebody's limited liability company somewhere. And so there is a lot of flexibility in terms of structuring things the way that a founder and their investors have conjured them up, for better and worse. I think a lot of the times people overcomplicate things a little bit. Over in corporation world, it's a little bit more straightforward because you have these creatures of statute, and so you have a bit more of an infrastructure in place that are limiting some of the decisions that you can make about how they work and fit together. but you still see quite a bit of diversity within the stock world, the corporation stock world. And this is going to be applicable to C corporations, not S corporations, because you're not allowed to have uh, different economic classes of stock in an S corp. You can have probably the most common distinction you see is between common stock and preferred stock. It's very typical for your founders and employees and advisors and others to receive the common stock. And common stock is going to be the base layer of your company's capitalization. This is the last people to get paid out upon a liquidity event. They're the ones who are bearing the most risk when it comes to the company's long-term success. But they are the ones who are oftentimes getting things for a lower overall price point. So their upside relative to their investment is the biggest. And so you have the cash investors who are oftentimes sitting on top of that. You do sometimes have cash investors come in at the common level, but that's pretty uncommon. There's a lot of reasons that I won't get into here that I don't recommend that. So you said you have your preferred class, and there's where some of the creativity can get into place. You have participating versus non-participating preferred. You have dividend generating preferred. You have a variety of different upsides that can be in place or not. But I think the simplest one to think about is that they get their money back out first. If the company is being sold or the company is winding down, those preferred investors sit higher up on the capitalization stack, and they get paid out. So that they bear more risk in the sense that they are often the ones who put cash in, but they bear less risk because it's a little bit easier to get to a threshold where they will see at least a return of their investment, if not a return on their investment.
So same question. Let's say our entrepreneurs are thinking about debt. How does, tell us a little bit about what a search for debt looks like and what debt can look like.
Yeah, it's a good question. So for very early stage investors, it's oftentimes difficult to find good quality debt. And there's a reason for that. When you have debt at its most basic, when you have a loan, you need to pay back that loan. People are familiar with, the short-term credit they receive in their credit card. You put things on your credit card, you need to pay it down. You got a monthly payment. You buy a house and you have a mortgage, you have a monthly payment. And in this context, you talk about servicing that debt. Do you have the cash revenue coming in the door necessary to service your debt in a way that allows for your business operations to continue? And when you're brand new, the answer is usually no. So at that very early inflection point in your going from, oh, you've got this all set up and now we need to fund things, it's oftentimes very difficult to receive debt funding. Now, that said, there are different kinds of debt that are beyond a simple loan. Something you do see very often with early stage companies would be a convertible note. So you have a standalone debt instrument where by its terms, the person who is giving the money is a lender and you, the company, are a borrower, and there are terms upon which it will be repaid. It may not require any debt servicing. You don't have any monthly payment. You don't have, you only pay it at the end. And further, you might have it be arranged where the expectation is that this will ultimately convert into equity based on some kind of mechanism. So that's in the early stage in company universe, that's the kind of debt I think you'd be most likely to see.
In our case of our injection mold business, could my intellectual property be sufficient enough, at least for some degree of debt as collateral, just the value of the IP, given that I might not?
That's a good point. That does make it a little bit different than some of the facts of somebody who's like really like early on. We under our facts here, we do have somebody that has developed something that was patentable and they have obtained a patent on it. And that does change the calculus where you may be better positioned to receive debt funding because the lender knows that in the worst case scenario, this is secured by that intellectual property, so I can make myself whole by becoming the owner of that IP. That does change the facts somewhat.
Great. So we've talked a little bit about the types of entities. We talked a little bit about the very basic types of financing available. Before we spring forward, I'm going to tap Robert to maybe slow our latte sipping friends down before they get too excited. And just as a general practical guide, Robert, what are some of the very basic steps they should take rather than, signing a good guy guarantee on a lease and going, for a factory and going crazy? What are some of the basic steps they should consider?
Well, at the end of the day, you've got to decide whether, the effort and the heartache and the pain of starting your business is going to be justified. And so that really depends on you're the first investor in the business, and you need to kind of do your own investment analysis in this business. What's the market opportunity? How are you going to win? How will what are your initial capital needs? Will those be sufficient to actually go to market? How will you finance it? Those basic kind of that vision is kind of a prerequisite, and you need to do a little analysis to kind of test it. The idea that, we're going to make widgets is great until you look at what else is in the market of other widget manufacturers and whether they make a pretty darn good widget that everyone's satisfied with, or they have some sort of competitive differentiator that you would have a hard time kind of answering, in a sales call. So that's kind of step one. Step two is, again, probably to your point, taking stock of your IP. Do you have any particular moats? In this instance, we have a patent. Is that patent give you a real competitive advantage? Can preventing other people from making your product? Could other people just copy your product, who have more resources, not just financial, but manufacturing capability, relationships, a platform, distribution? All of those questions you need to kind of figure out, but probably, or at least have a plan for before you go ahead. And that's because you're the investor, but also when you try to raise capital, your investors are going to ask these questions too. They want to understand, are you thoughtful? Do you have a plan to win? Or are you just kind of going on a hope and a prayer? And then, I would say that, if your business is heavily reliant on kind of a brand of any sort, then you should spend some time also just on the brand itself. How will you position the business? The brand vision that you might have. Spend a little time Googling it, seeing where its usage in the market. Speak with an IP attorney to see if the potential trademark is available that you could use for that. Your brand is, you don't want to have to rebrand kind of in the middle of your launch. So you really need to kind of lock that down relatively early. You don't need it on day one, but you want to have a vision of before you go into the market that you're not going to have to rebrand. It looks like a little bit of a bust too. Again, it looks like you didn't plan ahead if in fact you choose a name that on a quick Google search or any investigation people know will present issues for the business and by extension for potential investors.
Great. So our entrepreneurs have all been sitting around let's say they've been in a retro Starbucks that now doesn't cater just to takeaway and still has a few comfy seats sitting around. So they're all comfortable. They all understand this. They understand a little bit about financing. One's going to be the brand person and sales rep. The other's going to be the engineer. And then one's going to be more business development and finance. And they view their roles equally. So we have three equal partners, Andrew. What are the problems of governance can we anticipate, and how can we address them, and where do we do so?
Right. So in our case, fortunately, we've got not an even number of what would presumably be the directors. So, and I'll just mention it because say you contemplate a board of directors of 4 individuals, there's a possibility for a deadlock vote. So you need to have some mechanism in your bylaws, your operating agreement, your governing documents to address deadlocks and voting. And just more broadly speaking, voting rights and who has authority and what who can vote on what is important to outline in the governing documents. And some governing issues that will come up, are there restrictions on transferring your ownership? Typically, there's this concept of permitted transferees under LLCs and when and how you can transfer your ownership. And while we have three, equal owners here, say two of them decide, hey, now's the time to sell. We've got this opportunity to sell these shares for this price, but the third one doesn't want to. There's often what's called, not getting too far into the weeds, but drag along rights, where basically an entity it's a mechanism to prevent a minority shareholder from preventing a sale of the business. And then the flip side of that would be something like tag along rights, where a minority shareholder has the opportunity to participate in the sale of shares. Other issues that would come up are a right of first refusal for ownership of, the equity. Typically it'd be the company would have the opportunity first to purchase that equity and then the other shareholders. You need to address, new shares, issuances of new equity, preemptive rights for the existing owners. One thing we alluded to in the beginning is, what happens in the event of death or disability of one of the founders? Have you addressed that in the governing documents? Is there a plan? Is there a succession plan? And then just generally speaking, managing investor expectations, maintaining credibility with stakeholders, being accountable for your actions, are some of the points I would look at.
Thanks. I'm going to tap David now to talk about how some of these governance issues and succession issues might be handled and where they're handled, and serve up some, I don't want to say typical, because at least in LLC agreements and stockholders agreements, the topic seems generic on its face, but in my experience, having done oodles and oodles of them, maybe oodles squared, they're always unique to the founders. So, what are some more typical ways that these items are resolved, David?
Yeah, I mean, it's one of the things that you'll see in the cleanup of preparing for outside venture capital investment is you have founders of a technology startup who do not have their shares subject to any kind of vesting. And what do I mean by that? So if you set it up, you can set up a couple of different ways, but the long story short is you want to have a mechanism in place whereby if one of the founders leaves, either because they just want to go do something else or because they got hit by the uptown bus, that there is a mechanism in place to ensure that there is sufficient capital within the company to absorb that loss, redistribute that available capital in a way that then allows the company to move forward. And I say that the bus thing is a little bit glib, but it does happen, where you have unexpected losses of people, and this is one piece of that otherwise very tragic event that need not be catastrophic. You could have it be built in where there is a mechanism for the company to buy back their equity, some or all of it. There is variability there. You can have it where all of the unvested equity is repurchased or simply reverts to the company. You can also have it be where all of the equity is purchased back. I mean, some of it could be at some de minimis price. It could be at par value. It could be at fair market value. There's a great deal of variability. Where things get really hairy is when nobody's bothered to think about this, and then they need to think about it, because it's a very emotional and difficult time. Whether the departure was just somebody resigning or somebody passed away. You then have a situation where if this has not been spelled out within the company's documents. You then need to see what is happening with the estate of the deceased individual in that case. Or it can just be the death of the company. If you have a company that is extremely founder centric and they just walk away from it, there may be nothing to be done if there isn't a mechanism in place, and the business may just die. If you have something, I don't know, I'm blanking on a art studio or something where they're producing some sort of creative work that's central to the person, and they happen to have provided some equity to a couple of other people in lieu of cash early on for services rendered, and that person retires. There's no more business anymore. And so did you solve for it? Not necessarily, but does it matter? It also doesn't matter. As is the case with all of these things, it comes down to facts and circumstances. If you're building a business that sits within a particular playbook where you can lean on that and say, hey, generally speaking, these are things that are best practice. I brought up, being in an early stage technology startup. Like, there are a lot of these. We've gotten a lot of reps, folks that are in the ECVC kind of universe, and we can tell you within certain parameters that this is, if you're outside of them, you need a pretty good reason why you aren't doing it that way. And the same applies in other kind of subcategories of industry. I'm much less experienced, for example, in manufacturing. We're talking about manufacturing today. It's not been my area of expertise, and the way that they're capitalized and the way that they're financed isn't what I do most of the time. But my expectation would be that there are certain general guidelines of what the expectation is in terms of things like this, succession. And so engaging with counsel, thinking through these issues, avoids any kind of situation where you have to engage with, God forbid, probate or something really, really mucky. All the while, the company is sitting in limbo, lacking in management direction and overall just suffering atrophy.
I might add to that, as you might have heard, I mean, there's so many ways that there can be dysfunction in the organization from the get-go, and kind of how the documents are drafted and prepared is kind of an indicator to potential investors of what your intentions are and how people will stick around, and kind of how thoughtful have you been to planning. And these are hard conversations for founders to have amongst themselves. And a good lawyer can help facilitate that conversation in a way that, just Googling and saying, here's our plan, this is how we're going to break the logjam, usually doesn't get you there. I think one key element or factor or contribution that a lawyer will have with a startup is to kind of force these conversations that can be a little difficult, to make sure that they happen now at the start rather than, when you have a dispute.
I agree. And the way that at least that succession or someone leaving the business for whatever reason issue, I treat it similarly to the way I would be negotiating an executive compensation arrangement on behalf of a senior executive, kind of between good leaver and bad leaver. If you're a good leaver, meaning you've been terminated without cause, you die or become disabled, or perhaps you resign after a certain number of years, you should probably get 100% of the fair value of your vested equity. If you're a bad leaver, meaning you're quitting on the company during a certain period of time, or you breach a restrictive covenant agreement, or you terminated for some sort of concept of cause, there you should be taking a haircut. The question is, how much? I've seen it, as we say, a range. Sometimes I've seen $1, nominal. It's a very tough discount. And then other times I've seen, on the more, I don't want to say fairly side, but on the more generous side from the company side, it be 50% of fair market value, which means you could earn half your equity, steal from the company, but to the extent of your earned equity, you're going to get 50% of the fair market value of that. So, but I kind of look at it as one of the circumstances of departure. It's fun stuff, but I agree at some point in time, we as lawyers have to be consulted. So I want to go a little bit off the reservation here, which is, and if you have any thoughts, with selling your services or marketing your services or being available to startups when these founders come to you, what do you tell them? What do you offer? Do you offer them a startup package at a somewhat discount, carving out financing or prolonged negotiations with co-founders? What as an entrepreneur, what should I be shopping for? What kind of deal is attainable to get? Because I can tell you from the legal side, typically, no matter what the deal is, it's always that we are uh, taking or exposing ourselves to a short-term loss or risk for the benefit of helping to grow a loyal, very profitable client. But just I want to take everyone's temperature of what they're seeing now. It doesn't have to be your practice. Let's take it as to what you've seen.
Yeah, I'll go. I mean, I think we can offer fixed fee arrangements in some instances, often hourly. You also see sometimes lawyers just doing hourly, but writing off a substantial amount of their time. The reality is that you know, any lawyer that's representing a startup, there's a little bit of a tension there. A lot of startups have been sold this view that it's all forms, just give me your startup package and we'll move on. But as you're discovering here, there's a lot of counseling involved in this and a lot of planning and a lot of calls maybe amongst founders and sorting through other issues which can be time intensive, and it's not just handing something to a paralegal and saying fill out some forms. So on some level, I view my counsel at this stage as an investment in the client. And so, I would advise someone to also sell your lawyer in the business because you want to see that they want to make that investment, that there might be some potential upside and growth possibility. And that investment, lawyers typically don't invest in startups. There are conflicts of interest issues there. Some firms are a little different with regard to that. But they do want to see that there's follow-on business, that you're kind of a thriving business that will have other legal needs down the road, whether it be financing or maybe an exit. So yeah, I would say I often do see some sort of fixed fee arrangement, excluding things like a financing, or any sophisticated employment counseling, etc., for basic forms. But again, even the basics, I think we've all seen kind of form generators. If you're doing it that way, or if your counsel's doing it that way, they're probably doing it wrong.
Agree. All right, let's move on. Andrew, what are some of the positives and what are some of the negatives of getting equity financing?
Right. Okay. So as I was saying early on, you are giving up some ownership. Your ownership is being diluted. In exchange for the financing, the investor is getting equity and ownership in the entity. So you can also look at this somewhat as a pro, because, at the same time, they're getting their skin in the game, could potentially provide an opportunity to take, bigger or more calculated risks. So some of the pros, clear pros, would be there's no repayment obligation. They just get their equity. This could improve cash flow. Money's coming in. You're not having to service any debt. These investors might also bring expertise with them that maybe the original founders didn't have. Maybe they've got some special sauce, something that they can add and brings more value. Basically a synergy, 1 + 1 could equal 3, and the benefit of that. And then, one thing you'll find under debt financing, there's, a host of restrictions that'll come with a loan agreement or a credit agreement. What you can and cannot do with the money. Can you further invest it in developing new locations, etc. So you don't have restrictions like that, generally speaking, with equity. So some of the cons, reiterating, you're sharing in the profits, diluting the ownership. Finding investors, it doesn't just happen with the flip of a switch. It takes time. You need to get out there, find the opportunities, and then make it happen. And then there's also going to be, more potential opportunity for conflicts or differences of opinion between owners, Going back to those governance issues we were talking about a minute ago, if you have more owners, you have more people having a say in the situation, and you might not all disagree. And then finally, you do not have certain tax advantages that you would have with debt financing. So, with debt financing, you can, well, basically, you can't deduct dividends that are paid to investors like you do interest payments on debt. So that's just one practical, balance sheet consideration.
Okay. So let's say we've decided that we want equity financing because we don't want all the debt covenants, for example. David, how does a young company go about getting equity financing? Does it take an ad out in the paper? Does it have a Zeppelin with a big banner under it? What does it do? How do they prepare for it?
Don't do those things. To start, don't do that. So we have this thing called the Securities Act of 1933, and it makes it so that the offer or sale of securities in the United States of America either need to be registered or exempt from registration, which is a whole bunch of lawyer words in rapid succession. And we said we wouldn't have so many lawyer words, so I'll try to not do that. The the long and short of it is that you can't run around town physically or digitally saying, I'm raising money, come invest in my company. There are ways that you can do it. There are exceptions to this, but the general rule is don't do that. So how do you do it in reality? And this is part wearing my lawyer hat, part wearing my angel investor hat. It starts, as do so many things, with networking, getting out into your community, whatever that means to you, whether it's geographically, whether it's in your industry, whether it's within your skill set or related skill sets, whether it means digitally and being in those digital communities, being out there, being present, meeting people, and seeking out people who, frankly, have money, and are in of the disposition that they are going to invest that money in companies. And you don't begin by immediately showing up with your hand outstretched. There's a book that I send to new clients that I know are about to do a raise, and I'm blanking on the name. I think it's literally called like fundraising or something like that. It's a red book. It's $11 on Amazon. It's like 80 pages. And it's the again blanking on the gentleman's name in addition to the book, but it's coming from kind of a .com earlier like internet perspective, so it's a little bit dated, but the core principles there are very, very strong. Where the thing you don't want to do is to open up your raise and actually begin raising money without some degree of certainty that that round is going to be at least mostly filled, because investors tend to be a bit of copycat. Like they if you have a bunch of people investing and the person knows somebody else who's already investing, they're a lot more likely to write a check. And the inverse is, hey, this person I know talked to you and they didn't invest in you and you don't have anybody signed up right now. I'm not going to be the first money in the door. So those are some really important things to start thinking about. And you can get good advice about how to approach this, how to build up that conversation, approaching your that piece of your financial life cycle, by meeting people who resonate with you. So early advisors, a lawyer who does this kind of work and takes a shine to you and is willing to have a coffee and just talk you through what the process looks like. A lot of first-time founders in particular, you start talking about, the kind of tech life cycle of having a pre-seed financing and then your series seed and then your series A and series B and then a bridge round that's in there, and they start to gloss over, and you want to be able to talk that talk, understand what those kind of terms mean to the extent that they're relevant to your industry and the future that you're hopefully chasing. But there are people who will provide that guidance to you. I think this just comes back to a little bit of the working with early stage companies question we had a minute ago. A big thing for me is, I'm not in the business of squeezing water out of a stone. I'm cognizant of the fact that my services are expensive and that hiring me is a big investment. for my clients a lot of the time. And sometimes the time's not right, and they don't have the money yet. And then the advice really to them is, okay, you need to go and save a little bit of money to be ready for this journey, because this is going to be a big jump and you need to do it right. I can't advise you to take a shortcut here, because I'll say, don't do the LegalZoom thing. That's my big advice. Like, don't do that. It's a terrible idea. If you're going to do anything, there are services that are a bit more reputable and give you slightly better forms. So at least shell out $1,000 and do that. But really, you might need to take a breath, think through this, and build up that little bit of startup capital of your own before you walk down this journey, because it ends up making people make curious decisions, take money from curious sources, and that can actually end up scaring away that longer term substantial equity investor.
Thanks so much. So, Robert, to help close us out, let's throw in some, it can be a war story, it can be sort of practical applications. What happens in the marketplace where someone is sort of out there pounding the pavements, and what are some of, you can throw in your own additional do's and don'ts to that topic, bearing in mind episode two will be on raising capital. This should just be a little bit of teaser for those watching episode one.
Yeah, I mean, I guess the story that comes to mind is the last one I had, which is a client came to me and said, "Well, I'm an amazing entrepreneur. I've had runaway successes. Look at these exits I've had, but I've never raised capital. So I just partnered with this guy that told me how to do it. And it was a broker, and he told him how to raise capital from his buddies, and he violated maybe 20 different securities laws. And he said, well, how do I fix this? And it's heartbreaking for me to tell him there's no good answer to this. If you do violate those securities laws, then you need to there's a huge process for offering to redeem all of the stock and making disclosure to the stockholders. He said, what if I don't do it? And I'm like, well, if you don't do it, you won't be able to raise more capital in the future. And you're not really going to be reputable with other firms. And you've got a huge liability going forward for other investors. And all of this came about because he relied on someone, not a lawyer, who said, here's the way, here's a hack. It looked like the legal documentation he had used looked right, but when you looked at it, it was way too simple, much like something that would be generated from a ChatGPT. Had lots of questions about who owned what, who would have priority in payments. And that was just the start. And so the business is sort of dead on arrival even before they launch. You can't really, had a great name, bought a trademark, had a great plan, but can't really raise capital, can't really go into the market, doesn't want to put more money towards this liability, and needs to just sort of walk away from the business and maybe start anew, or spend a lot of money to fix it at a stage where it's too premature. So you see these issues where shortcuts are made. I've got another client that started a business in the UK, but shortly thereafter moved to the United States and has now subjected themselves to UK and United States income tax. And we had a huge transfer pricing issue, and it became a cloud on what could have been an amazing exit for them. These basic startup issues that I know it's tough, you don't have a lot of money, you want to find the shortcut. It's good to just have someone that can say, to help you call the balls and strikes. There's some risks that are okay to take, but you want a partner to help you sort through those risks. Not everything that you see online and the quick advice applies to you, because there's always a caveat. That would be my advice.
Thanks so much. This has been a really fun one. I don't think we should be allowed to have so much fun without charging for it, but so be it. Thanks again to our sponsors, the National Law Review and Max Asset. Thank you for another entertaining and yet educational production of Financial Poise. You can look for Financial Poise webinars wherever better continuing education webinars are sold. You can join me on April 8th, 2026 for episode 2. That's 2 of the Startup Small Business Advisor 2026 series on raising capital. We gave you a little bit of a teaser about some of the things that we'll be talking about in greater detail for episode 2. Raising capital will be also talking about negotiating with potential investors when we take a deeper dive into some of the topics we chatted about. Until then, stay well, stay safe, and I guess stay warm. It's cold out there. Thanks, everyone.
Thanks, everyone.
Thank you.
Thank you.